The Economic and Financial Crimes Commission, EFCC, says it will appeal the judgment of Justice Charles Agbaza of the Federal Capital Territory High Court in Abuja here, dismissing the 10-count charge of corruption brought against the former secretary to the government of the Federation, Lawal, and others. In a statement issued by Wilson Owujaren, head media and publicity, the Commission says it will obtain a copy of the judgment for urgent review and challenge its validity at the appellate court.
And the Court of Appeal sitting in Sokoto has reserved judgment in the Zamfara State People's Democratic Party governorship primary election that was nullified by the Federal High Court sitting in Gusau. The court reserved judgment after listening to the arguments of the counsel to the parties. Well, the lower court had in September 2022 nullified the party's primary election that produced Dauda Lawal Dare on the ground, among others, that women delegates were not allowed to participate. The court consequently ordered a fresh primary elections. The party complied with the court order and conducted a fresh primary, which again produced Dauda Lawal Dare, but the outcome was rejected by one of the aspirants, Sani Bakoy, who headed to the Federal High Court Gusau and eventually nullified the primary election.
The judgment say, go and do another election. They have complied with that judgment. They have done another election. The question would have been, if they had won, if the second election was allowed to stand, would they still be in this court challenging this appeal? The answer is no. What is important is that they are more interested in being on the ballot paper, both in conducting the second election and also coming to this appeal. They have lost in that one. They are actually hoping that something will come out of it. But wait and see.
I cannot start to comment on the appeal if it goes through. I think it might be better for us to wait until the appeal is allowed or dismissed or whatever it is. But you can see that when I argue the appeal, the release we asked for included that the primary that was conducted on May 25, 2022, and the result of that primary be affirmed, and that the PDP candidate should remain as per that primary that was held on 25th of May 2022.
Right, at this point, let's bring in our guest, Frank Tietie, Rise News analyst, to help us unpack the implications of of course, the court judgment on Lawal, former secretary to the government of the Federation, who's been discharged and acquitted. Good to have you on Newsnight tonight.
My pleasure.
Yeah, on a Friday like this, sometimes it can be hectic. But let's talk about your thoughts first, I mean, on this Federal High Court acquittal and the reasons given by the court that the EFCC did not establish a prima facie case against ex-SGF and, of course, co-defendants.
Well, you know, I haven't seen the judgment because it's a quite recent judgment, but from the reports that I've read, it's an application of a no-case submission, a technical term in law, where the prosecution finishes the presentation of all of his pieces of evidence in support of the charges, in support of the case that it has. And when, after doing that, it doesn't really disclose any case to answer on the surface of it. That is, it's referred to as the prima facie case. Right. At that point, it becomes very difficult for the court to proceed. The court now proceeds to now say, the defendant, that is the person who has been charged, does not need to even enter a defense, and proceeds to now discharge and acquit the defendant. And that's exactly what happened. It's not as if Lawal put up any defense that was on its merit. He wasn't discharged and acquitted on the basis of the fact that he had evidence that countered that of the EFCC to the point that the court found him not culpable in any way and then discharged him. So it's an interesting scenario, meaning that the presumption of innocence was there all the time, but he didn't quite take advantage of it. There was a lot of sensationalism when the matter came up in 2016, 2017. The Senate at that time, Senator Shehu Sani-led committee at that time, successfully created enough hullabaloo given the fact that the president at that time was still enjoying the anti-corruption status on which he rode to the presidency. So Nigerians looked greatly forward to what was going to come out of the case, and the EFCC needed to rise up to the occasion. So it's not as if the EFCC didn't do anything, if the EFCC didn't charge the matter to court, it would have been a different matter. But from one report that I read,
EFCC again bungled the case.
Not necessarily
Okay.
so, not necessarily.
But the court did mention issues around the witnesses' broth, that no ingredients regarding the case was extracted enough or was gotten from them. And that, I mean, that brings to question the quality of investigation by the anti-graft agency, the EFCC.
I think it was an investigation by the Senate under its powers provided for under Section 88 of the Constitution. Now, the EFCC needed to have moved. The EFCC did its best to present about 11 witnesses. But you see, it's in a situation where one of the witnesses of the EFCC begins to say, well, the EFCC ought not to have brought this matter to court in the first place after the Bureau of Public Procurement actually did an analysis of the he vetted that particular contract and didn't see any conflict of interest on the part of the former SGF. At that point, the court would have been weak. There's nothing the court would do. The court has to always remain as an impartial arbiter, where it cannot force itself to listen to loud public opinions that condemned Babachi Lawal at that time. Even though the man kept on saying, "Look, I'm being set up." And when they said, I recall that famous "Who is the presidency?" the question when he asked, all of that
may have offended some people.
Yes, indeed.
But let's even, some Nigerians are already questioning the administration of justice system in Nigeria, in spite of the overwhelming evidence in this particular matter. Does this judgment, does it deal another blow on the war against corruption in any way or form?
Certainly not. I don't want to think about that.
Okay.
Let us not. You see, it is fundamental to presume every Nigerian to be innocent until proven guilty. You see, if there is a problem with the administration of criminal justice, it should be with delay. How did it take nearly 6 years, or more than 5 years, or so, for this matter to be established that Babachi Lawal was innocent, when it could have been determined within 6 months? Babachi Lawal was a political appointee of the president, and political appointments are reflect regional and certain interests. All of that was lost because there were charges, there were presumptions onto the contrary that the man he was a thief. He had used his position as SGF to influence the presidential initiative on the Northeast at that time to award contract to his company. Whereas we didn't note about the fact at that time. He wasn't loud enough in his defense to say, I had resigned from Roller Vision, I'm no longer a director. At the same time, this went through due process. I didn't know anything about it. Now, the only institution that could have determined whether or not he was innocent wasn't a panel of inquiry, or wasn't a political senate that had a roller coaster period at that time under Saraki, but it was a court. But why would it take the court 5 years to determine that? So all of those interests Babachi Lawal represented were lost, and can they recover them now? Certainly not.
Okay, but the EFCC says it will appeal, it's not giving up. What do you foresee as the task or challenge ahead of them here? I mean, they had 11 witnesses that didn't move the needle for them.
Absolutely.
And we're talking about 4 years after, 4 or 5 years after. How huge a task is this for the EFCC?
It is indeed a huge task. First and foremost, if the EFCC decides to appeal the decision, it's well considered, because you need to consider the overwhelming public opinion that is tilted already against Babachi Lawal. And if the EFCC does not do anything about that, it will look as if it is assuming to be compromising the matter. But again, the court doesn't deal with sentiments. It's very difficult to overturn the findings of a lower court. So, for example, if a court has recorded a certain piece of evidence to be rejected, it will be difficult for it to be, to be tendered and accepted again at the appeal level. So, in this case, we're talking about a particular witness that said that was contradicting the EFCC, an EFCC witness contradicting it, saying that, well, under cross-examination anyway, it wasn't the intention of the witness to contradict the EFCC. But cross-examination reveals quite a lot. That if you are convinced that the BPP actually vetted this contract and that Babachir Lawal did not have any conflict of interest, he was not sitting on the board of Pine at that time, neither was he on the contract tenders board, so there was no connection whatsoever to him. If you had this as a belief at that time as an EFCC prosecutor, would you have considered prosecuting this matter? And the witness said no. You know, such findings are permanent. And would the Court of Appeal on this, because there's a public opinion, Nigerians are just willing to sacrifice the man, then the Court of Appeal will change? No, the court does not kowtow to public opinions. Rather, it deals with matters of law, facts, and justice. And on the other hand, right, it might not necessarily overturn it expectedly.
Should the FCC or EFCC actually, should they have trimmed the charges maybe to 2 or 3, smoking gun, and not necessarily this seemingly
Babachir Lawal wasn't the only one that was charged. There were companies that were charged. These are artificial persons, and you will require specific charges that are tailored towards the particular acts of these persons that were, were co-accused in the matter. So it doesn't necessarily matter that the charges could be as many as whatever, but the elements that support those charges may not be many, but the charges could be as many because of the number of persons that are involved in the charge.
I wonder how EFCC can actually strengthen its prosecutorial.
No, I need to make this point because this didn't happen under the current EFCC dispensation. Yeah. Now, we've noted, and I have had the opportunity to note it here, that there's been a radical shift in the way the EFCC goes about its investigation and prosecution. We've noted that. And to that extent, we think that the EFCC will properly advise itself, after it has studied the judgment, whether or not to waste state resources in pursuing it, or to go back to see that it can actually end these forms of corruption, even before they start. In this case, we cannot in any way refer to Babachir Lawal as someone who has been involved in any act of corruption. He has been discharged and acquitted by the court.
Fingers crossed. Thank you so much, Frank Tietie, as usual, Arise News analyst.